Please subscribe, like and share this content. It means a lot to us. Thank you in advance.
Cornell Law School. U.S. Code, Title I. U.S. Code, Title I. 1 U.S. Code Chapter 2, Acts and Resolutions, Formalities of Enactment, Repeals, Sealing of Instruments. 1 U.S. Code Paragraph 101, Enacting Clause. The enacting clause of all acts of Congress shall be in the following form: be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. 1 U.S. Code Paragraph 102, Resolving Clause. The resolving clause of all joint resolutions shall be in the following form: resolved by the Senate and House of Representatives of the United States of America in Congress assembled. 1 U.S. Code Paragraph 103, Enacting or resolving words after first section. No enacting or resolving words shall be used in any section of an act or resolution of Congress except in the first. 1 U.S. Code Paragraph 104, Numbering of Sections. Single proposition. Each section shall be numbered, and shall contain, as nearly as may be, a single proposition of enactment. 1 U.S. Code Paragraph 105, Title of Appropriation Acts. The style and title of all acts making appropriations for the support of government shall be as follows: Enact making appropriations, here insert the object. For the year ending September 30th, here insert the calendar year. 1 U.S. Code Paragraph 106, Printing bills and joint resolutions. Every bill or joint resolution in each House of Congress shall, when such bill or resolution passes either House, be printed, and such printed copy shall be called the engrossed bill or resolution as the case may be. Said engrossed bill or resolution shall be signed by the Clerk of the House or the Secretary of the Senate, and shall be sent to the other House, and in that form shall be dealt with by that House and its officers, and, if passed, returned signed by said Clerk or Secretary. When such bill, or joint resolution shall have passed both houses, it shall be printed and shall then be called the enrolled bill, or joint resolution, as the case may be, and shall be signed by the presiding officers of both houses and sent to the President of the United States. During the last 6 days of a session such engrossing and enrolling of bills and joint resolutions may be done otherwise than as above prescribed, upon the order of Congress by concurrent resolution. 1 U.S. Code Paragraph 106a, Promulgation of Laws. Whenever a bill, order, resolution, or vote of the Senate and House of Representatives, having been approved by the President, or not having been returned by him with his objections, becomes a law or takes effect, it shall forthwith be received by the Archivist of the United States from the President, and whenever a bill, order, resolution, or vote is returned by the President with his objections, and, on being reconsidered, is agreed to be passed, and is approved by 2/3 of both Houses of Congress, and thereby becomes a law or takes effect, it shall be received by the Archivist of the United States from the President of the Senate, or Speaker of the House of Representatives in whichsoever House it shall last have been so approved, and he shall carefully preserve the originals. 1 U.S. Code Paragraph 106b, Amendments to Constitution. Whenever official notice is received at the National Archives and Records Administration that any amendment proposed to the Constitution of the United States has been adopted, according to the provisions of the Constitution, the Archivist of the United States shall forthwith cause the amendment to be published, with his certificate, specifying the states by which the same may have been adopted, and that the same has become valid, to all intents and purposes, as a part of the Constitution of the United States. 1 U.S. Code Paragraph 107, Parchment or paper for printing enrolled bills or resolutions. Enrolled bills and resolutions of either House of Congress shall be printed on parchment or paper of suitable quality as shall be determined by the Joint Committee on Printing. 1 U.S. Code Paragraph 108, Repeal of Repealing Act. Whenever an act is repealed, which repealed a former act, such former act shall not thereby be revived, unless it shall be expressly so provided. 1 U.S. Code Paragraph 109, Repeal of Statutes as affecting existing liabilities. The repeal of any statute shall not have the effect to release or extinguish any penalty, forfeiture, or liability incurred under such statute, unless the repealing act shall so expressly provide, and such statute shall be treated as still remaining in force for the purpose of sustaining any proper action or prosecution for the enforcement of such penalty, forfeiture, or liability. The expiration of a temporary statute shall not have the effect to release or extinguish any penalty, forfeiture, or liability incurred under such statute, unless the temporary statute shall so expressly provide, and such statute shall be treated as still remaining in force for the purpose of sustaining any proper action or prosecution for the enforcement of such penalty, forfeiture, or liability. 1 U.S. Code Paragraph 110, Saving Clause of Revised Statutes. All acts of limitation, whether applicable to civil causes and proceedings, or to the prosecution of offenses, or for the recovery of penalties or forfeitures, embraced in the revised statutes and covered by the repeal contained therein, shall not be affected thereby, but all suits, proceedings, or prosecutions, whether civil or criminal, for causes arising, or acts done or committed prior to said repeal, may be commenced and prosecuted within the same time as if said repeal had not been made. 1 U.S. Code Paragraph 111, Repeals as evidence of prior effectiveness. No inference shall be raised by the enactment of the Act of March 3, 1933, Chapter 202, 47 Stat. 1431, that the sections of the revised statutes repealed by such act were in force or effect at the time of such enactment, provided, however, that any rights or liabilities existing under such repealed sections shall not be affected by their repeal. 1 U.S. Code Paragraph 112, Statutes at Large, Contents, Admissibility and Evidence. The Archivist of the United States shall cause to be compiled, edited, indexed, and published, the United States Statutes at Large, which shall contain all the laws and concurrent resolutions enacted during each regular session of Congress, all proclamations by the President in the numbered series issued since the date of the adjournment of the regular session of Congress next preceding, and also any amendments to the Constitution of the United States proposed or ratified pursuant to Article V thereof since that date, together with the certificate of the Archivist of the United States issued in compliance with the provision contained in Section 106B of this title. In the event of an extra session of Congress, the Archivist of the United States shall cause all the laws and concurrent resolutions enacted during said extra session to be consolidated with, and published as part of, the contents of the volume for the next regular session. The United States Statutes at Large shall be legal evidence of laws, concurrent resolutions, treaties, international agreements other than treaties, proclamations by the President, and proposed or ratified amendments to the Constitution of the United States therein contained, in all the courts of the United States, the several states, and the territories and insular possessions of the United States. 1 U.S. Code Paragraph 112A, United States Treaties and other international agreements, contents, admissibility and evidence. A. The Secretary of State shall cause to be compiled, edited, indexed, and published, beginning as of January 1, 1950, a compilation entitled United States Treaties and Other International Agreements, which shall contain all treaties to which the United States is a party that have been proclaimed during each calendar year, and all international agreements other than treaties to which the United States is a party that have been signed, proclaimed, or with reference to which any other final formality has been executed, during each calendar year. The said United States treaties and other international agreements shall be legal evidence of the treaties, international agreements other than treaties, and proclamations by the President of such treaties and agreements, therein contained, in all the courts of the United States, the several states, and the territories and insular possessions of the United States. B. The Secretary of State may determine that publication of certain categories of agreements is not required if the following criteria are met. 1. Such agreements are not treaties which have been brought into force for the United States after having received Senate advice and consent pursuant to Section 22 of Article 2 of the Constitution of the United States. 2. The public interest in such agreements is insufficient to justify their publication, because a. As of the date of enactment of the Foreign Relations Authorization Act, fiscal years 1994 and 1995, the agreements are no longer in force. 1b. The agreements do not create private rights or duties, or establish standards intended to govern government action in the treatment of private individuals. C. In view of the limited or specialized nature of the public interest in such agreements, such interest can adequately be satisfied by an alternative means. Or d. The public disclosure of the text of the agreement would, in the opinion of the President, be prejudicial to the national security of the United States. And 3. Copies of such agreements, other than those in paragraph 2d, including certified copies where necessary for litigation or similar purposes, will be made available by the Department of State upon request. C. Any determination pursuant to subsection B shall be published in the Federal Register. D. The Secretary of State shall make publicly available through the Internet website of the Department of State each treaty or international agreement proposed to be published in the compilation entitled United States Treaties and Other International Agreements not later than 180 days after the date on which the treaty or agreement enters into force. 1 U.S. Code Paragraph 112b, United States International Agreements, Transmission to Congress. A. The Secretary of State shall transmit to the Congress the text of any international agreement, including the text of any oral international agreement, which agreement shall be reduced to writing. other than a treaty, to which the United States is a party as soon as practicable after such agreement has entered into force with respect to the United States, but in no event later than 60 days thereafter. However, any such agreement, the immediate public disclosure of which would, in the opinion of the President, be prejudicial to the national security of the United States, shall not be so transmitted to the Congress, but shall be transmitted to the Committee on Foreign Relations of the Senate and the Committee on International Relations of the House of Representatives under an appropriate injunction of secrecy to be removed only upon due notice from the President. Any department or agency of the United States government which enters into any international agreement on behalf of the United States shall transmit to the Department of State the text of such agreement not later than 20 days after such agreement has been signed. B. Not later than March 1, 1979, and at yearly intervals thereafter, the President shall, under his own signature, transmit to the Speaker of the House of Representatives and the Chairman of the Committee on Foreign Relations of the Senate a report with respect to each international agreement which, during the preceding year, was transmitted to the Congress after the expiration of the 60-day period referred to in the first sentence of subsection A, describing fully and completely the reasons for the late transmittal. C. Notwithstanding any other provision of law, an international agreement may not be signed or otherwise concluded on behalf of the United States without prior consultation with the Secretary of State. Such consultation may encompass a class of agreements rather than a particular agreement. D. 1. The Secretary of State shall annually submit to Congress a report that contains an index of all international agreements, listed by country, date, title, and summary of each such agreement, including a description of the duration of activities under the agreement and the agreement itself, that the United States, A, has signed, proclaimed, or with reference to which any other final formality has been executed, or that has been extended or otherwise modified, during the preceding calendar year, and B, has not been published, or is not proposed to be published, in the compilation entitled United States Treaties and Other International Agreements. 2. The report described in paragraph 1 may be submitted in classified form. E1. Subject to paragraph 2, the Secretary of State shall determine for and within the executive branch whether an arrangement constitutes an international agreement within the meaning of this section. 2a. An arrangement shall constitute an international agreement within the meaning of this section, other than subsection C, irrespective of the duration of activities under the arrangement or the arrangement itself. B. Arrangements that constitute an international agreement within the meaning of this section, other than subsection C, include the following: I. A bilateral or multilateral counterterrorism agreement. 2. A bilateral agreement with a country that is subject to a determination under Section 6J1A1 of the Export Administration Act of 1979, 50 U.S.C. App. 2405 J1A, Section 628A of the Foreign Assistance Act of 1961, 22 U.S.C. 2371A, or Section 40D of the Arms Export Control Act, 22 U.S.C. 2780D. F. The President shall, through the Secretary of State, promulgate such rules and regulations as may be necessary to carry out this section. G. It is the sense of Congress that the executive branch should not prescribe or otherwise commit to or include specific legislative text in a treaty or executive agreement unless Congress has authorized such action. 1 U.S. Code Paragraph 113, Little and Brown's edition of Laws and Treaties, Slip Laws, Treaties and Other International Acts Series, Admissibility and Evidence. The edition of the Laws and Treaties of the United States, published by Little and Brown, and the publications in slip or pamphlet form of the laws of the United States issued under the authority of the Archivist of the United States, and the treaties and other international acts series issued under the authority of the Secretary of State shall be competent evidence of the several public and private acts of Congress, and of the treaties, international agreements other than treaties, and proclamations by the President of such treaties and international agreements other than treaties, as the case may be, therein contained, in all the courts of law and equity and of maritime jurisdiction, and in all the tribunals and public offices of the United States, and of the several states, without any further proof or authentication thereof. 1 U.S. Code Paragraph 114, Sealing of Instruments. In all cases where a seal is necessary by law to any commission, process, or other instrument provided for by the laws of Congress, it shall be lawful to affix the proper seal by making an impression therewith directly on the paper to which such seal is necessary, which shall be as valid as if made on wax or other adhesive substance.